5, 4, 3, 2, 1.
This Honorable Court of Criminal Appeals of Tennessee is now in session.
Welcome to the continuing February docket of the Court of Criminal Appeals for the Western Section. The panel today is Judge Camille McMullen from Memphis, Judge Ross Dyer from Memphis, and I'm Kelly Thomas from Maryland. The arguments, as always, are 20 minutes aside. I see two lawyers here. I presume you both are going to address some of the issues. If you'll tell me how you want to apportion your time, then we can do that accordingly, and let me know if you want to reserve some rebuttal time. And the state, of course, has 20 minutes. There aren't any preliminary matters, are there, Mr. Clerk?
No, Your Honor.
Okay, you call the next case.
Estate of Sedley Alley versus State of Tennessee.
Good afternoon, Your Honors. This is Paul Clement for the appellants. I'll be the sole lawyer speaking today for the appellants. My co-counsel here just to supervise me. And I would like to reserve 5 minutes for rebuttal if I could.
Yes, sir. You may. Go ahead.
Thank you, Your Honors, and may it please the court. The statute at issue here authorizes a person convicted or sentenced for first-degree murder to petition for access to DNA evidence at any time, notwithstanding any other provision of law governing post-conviction relief to the contrary. The act includes 4 and only 4 requirements for access, none of which limits relief to individuals in custody or still living. Despite that clear authorization for relief, the state argues that its own actions in executing a convicted defendant extinguish not only a life, but any claim for access to evidence in the state's exclusive possession that might demonstrate that the state has executed the wrong person. That cannot be right. If the state had adopted a policy of automatically destroying all DNA evidence concerning a crime, including trial exhibits that would otherwise be kept indefinitely, immediately after an execution, it would be an obvious injustice and due process violation. But if the state cannot destroy evidence just because it's executed the defendant, then it makes no more sense for the state to be able to cut off access to the same evidence just because they've executed an individual. That is especially true where the plain text of the statute and both of the purposes identified by the Tennessee Supreme Court in the Powers case support allowing access even in the case of an execution. Now, the state's basic response is to fall back on general principles of habeas law that limit post-conviction relief to a living individual subject to some form of ongoing custody.
Mr. Clement,
But yes, Your Honor.
If the petitioner was not initially entitled to have the evidence requested tested, how would the estate, how does the estate get that same opportunity? I mean, if he wasn't permitted to test the DNA evidence while he was living, how is the estate permitted to in his death on his behalf?
Well, Your Honor, the way that I would understand it is if Mr. Alley were alive today, I don't think there would be any question that he would get access to this information, because the principal basis on which he was denied access to this information was a misunderstanding of the DNA statute that was corrected in the Powers case.
You're saying that was the principal basis. There were other reasons, primarily, why this court, I think twice denied, this court and the Tennessee Supreme Court denied DNA testing in this case.
Well, Your Honor, with respect, I don't think there was any independent ground that wasn't infected by the error that was corrected in Powers. So it's true that after the court said that you can't get DNA to test other people who might be out there in a DNA database, after they said that, they said, well, the evidence here doesn't create a reasonable possibility of that the individual wouldn't be convicted or sentenced to this crime.
How do you get around that?
Well, I think, I mean, two things, Your Honor. One is, I mean, we'd be happy to fully brief this in front of Your Honors or in front of the principal, the court of first instance, but that's not the ground on which we were poured out of court. But second, just to give you a sense of our argument on that, we think it is quite clear that the way that this court in Sedley 2 analyzed the evidence was in light of the reality that they thought the only way that you could use the evidence was to sort of test whether the individual's DNA was on the materials and not whether some third party's material was on the materials. And I think if you look not just at the holding of Powers on the question of whether it's appropriate to use DNA for these broader purposes, but also look at the application of that rule in Powers itself, I think this case is a much stronger case for access to the evidence than Powers. I mean, in Powers, there was very strong evidence that this was part of a pattern of the same individual engaged in the same conduct with another set of girls just in the same time period. And there was reason to believe that there would actually be DNA evidence of a third party who had had consensual sex with one of the girls beforehand. And despite all of that, once the Supreme Court in Powers said that the analysis properly takes into account the ability to test the DNA against third parties, the court at that point said, yeah, Mr. Powers is entitled to test the DNA. So I would think, Your Honor, I realize that you may have some trouble with the premise, but I would think that if Mr. Alley were still alive, we would not have a problem overcoming that hurdle. And again, that's not why the trial court dismissed our petition. The trial court dismissed the petition applying a bright line rule that you can never bring one of these claims once the person who is convicted of the crime has died or been executed by the state. And we think that's wrong. And if you'll accept with us the premise that I suppose could be tested in the first instance in the trial court, but if you accept the premise that if Mr. Alley were alive, he would be able to get access to the evidence, then it seems to me that there is a powerful case based on the text of the statute, the legislative purposes as identified in Powers, and constitutional avoidance principles, that same right just passes to the estate, and the estate can prosecute the action essentially on Mr. Alley's behalf. And if I can sort of break that down, I think that the text of the statute seems quite favorable to our position because it says that the action can be brought at any time, which is part of the reason that I think that if Mr. Alley were still alive, he would be able to get access to this information. Obviously, as we've discussed, he'd have to clear the 4 hurdles that are actually in the statute, but we think he could. But those are,
we deal with that as a court, I guess, as a court. Those things have already been set. So I guess I'm going to let you continue your argument, but with that in mind, as you go on, address the fact that we've addressed those things in opinions twice. And so you're saying that the estate is bringing something different that will make those findings more favorable for DNA testing. And I hate to keep interrupting you. I know you don't have time, but just keep that in mind. That is a troubling factor. We've already addressed that twice when Mr. Adley was living.
So Your Honor, I think there are 2 reasons why, or maybe 3, why you wouldn't apply some notion of issue preclusion or collateral estoppel here. One is, I think that is fundamentally inconsistent with the at any time language in the statute. And I think it's fairly well established that you don't simply apply issue preclusion under this particular provision of the statute.
No,
Second,
that's when you can bring an action, not the issues in and of itself or who's bringing the action.
I agree, Your Honor, but I think that courts have read that at any time language to specifically provide that principles like collateral estoppel and issue preclusion do not apply. The second reason you wouldn't find any kind of issue preclusion or collateral estoppel here is because the court in Sedley 2 did demonstrably apply the wrong standard. But the third reason that's unique to this statute is that DNA testing does not stand still. And it is improved over time in its accuracy and in its ability to get coherent results. So I think it is very clear, in my mind anyways, that consistent with the intent behind the statute, that if you wanted to, if an individual who asked to test some information based on the DNA technology of 2003, then tried to file a petition to try to get that evidence tested under the DNA technology of 2020, that they would be entitled to a fresh look under the at any time language and under the purposes of the statute, which I think recognize that this DNA testing moves on. Now, this is a situation where, because of an incorrect ruling of law, we've never had the chance to test this evidence. This is a situation where the DNA testing has improved. So I think that we have reasons to believe that we could get a favorable result here based on the DNA technology of 2021 that might not have been available in 2006. So we think for multiple reasons, we can overcome that hurdle. But I do think, with respect, if that's what's primarily troubling you, the right answer would be to reverse and remand for the trial court to take a fresh look at all of that, because that is simply not the basis on which the trial court ruled. And
I agree, though, that all four elements have to be met before any DNA testing will be ordered, right?
Absolutely, Your Honor. And we think, I mean, we stand ready to try to make that showing. We did our level best in the petition that we filed in with the trial court, and we think we carried our burden. We, of course, don't know because the trial court didn't rule on that ground.
Right.
But I noted that holding against us, for example.
In Powers, the first Alley case was cited for that proposition.
For the proposition that all four factors have to be satisfied.
Correct.
And then, of course, as Your Honor well knows, the court then went on to essentially abrogate the result in Alley 2.
Correct. Yes.
And
which I thought made a lot of sense.
I don't think it did either. With all respect, Your Honor, and I do think that, as I alluded to, Powers is very helpful in a couple of respects. One is, I think if you read sort of the rest of the opinion, so to speak, the analysis there is very favorable, I think, for a convicted individual where the evidence and the circumstances were, I think, frankly, more dire for the convicted individual than are present here. But the second thing is, the Tennessee Supreme Court went on to, I think, definitively hold what the purposes of the post-conviction DNA statute are. And it identified those two purposes as exoneration and identification of the true perpetrators of the offense. And I think what's critical is that both of those purposes continue to be served even after an individual has either served their entire sentence and is no longer in custody, or has been executed or passed away. There's still an interest in exoneration. And if the state has incarcerated or convicted the wrong person, there is still a very vibrant interest in trying to find the true perpetrator, especially for a crime like murder, where there's not a statute of limitations and you could continue to prosecute the correct person. And I think that kind of distinguishes it from a more typical post-conviction remedy. In the more typical post-conviction remedy, the principal focus is the fact that the individual is still in the custody of the state. And so that's why under habeas or post-conviction relief, if the individual is no longer in custody, you can't bring that kind of action. But here, in the very first sentence of the provision, the legislature said that we're not going to apply the ordinary rules of post-conviction relief. And I think that makes sense because what's important for purposes of this statute is not so much whether the defendant is still in the exclusive custody of the state, but whether the evidence is in the exclusive custody of the state. And of course, that's one of the four things we'd have to show, that the state still has the custody of the evidence and it's still in a state where it can be productively tested for DNA purposes. But if we can show that, I think all of the interests that stand behind the statute and the purposes identified by the Tennessee Supreme Court and powers are served by allowing the testing of that information.
So
And,
how do we apply state law to this?
well, I think there are multiple paths to applying the state law in this case. First of all, I think you can just essentially apply the plain text of the statute. I think even though he's no longer living, Mr. Alley is still a person convicted of first-degree murder, and he's entitled to file the petition at any time. It's something of a procedural detail, I think, that the action is being filed by the estate rather than the individual. But of course, that's what Tennessee law provides, that when somebody has essentially a right of action, but are no longer living, then under the survivorship statute and the rest, the way you continue to prosecute that action is bringing the action in the name of the estate. And I think that principle—
The criminal code for sure does not define a person as an estate or anything other than a person as you and I would think about it under the Webster's definition of a person, a living being. And even if you want to bring in the civil code, when it talks about an estate's rights, it doesn't contemplate something like this in any way. And then the legislature finally, if the legislature wanted the PCDNA Act to survive to the estate, they could have easily written it into the statute, and they did not.
Well, with respect, Your Honor, I don't think that's the right default principle to apply here. I think let me ask you this, and then I'll let you answer the four questions I just asked you. Why is me not reading the plain language of the statute, which says a person convicted of a crime can bring this action? Why is that not the default immediate setting from where we jump off? Well, so Your Honor, I think that is the default where you start off, which is the language of the statute,
which is not ambiguous.
I don't know whether it's ambiguous or not, Your Honor. I think it's unambiguous in my favor. The premise of your question seems to be it's unambiguous against me, which strikes me that maybe it's in fact ambiguous. But I don't think when somebody passes away, they cease being a person for plain language purposes. I think still a person.
I think a person is defined as a living being. If you just pull up Webster's definition, a person is defined as a living being.
With all due respect, Your Honor, I mean, if you ask me, is Martin Luther King a person? I would say absolutely he's a person. He's not fictional. He lived, he was assassinated, but he's a person. So in plain language, and it's not a defined term within this provision, which is why I think you have to look somewhere else. And I looked at background principles. There are all sorts of statutes, Your Honor, including 42 U.S.C. 1983, or FOIA is just another example, where the person who gets to bring the action is defined as a person. And yet courts uniformly hold that if the person who has the cause of action or the right of action passes away, then you just apply survivorship statutes, and then the action proceeds. It doesn't abate with the person's death.
In civil matters.
The only problem that I have with that, I guess, analysis or comparison, those are all civil matters, okay? And in a criminal case, you have to have finality. And I think that is where the issue becomes moot when the petitioner, defendant, whoever has the action passes. And in this case, you don't have a live defendant or petitioner. And those civil concepts that you refer to don't apply, or I have a hard time applying them. That's probably the best way to put it.
I've been so engrossed in the argument that I've let you encroach about 3 minutes on your rebuttal time, but we'll be a little bit lenient on that. So if you could wrap this up fairly soon, then I'll still give you your 5 minutes.
Thank you, Your Honor. And I'll just very briefly say that, one of the principal survivorship provision, which is 25-101, just talks about actions not abating. It's not even specific as to civil actions. And second, Your Honor, I'll certainly grant you that you tend to think of survivorship most often in the context of civil actions. But I think that, this court and the Tennessee Supreme Court have said that these post-conviction proceedings are a hybrid of civil and criminal. And the one thing we know from the text of this statute is that disabilities that are generally present with respect to post-conviction relief do not apply to the DNA provision specifically, because that's what the first sentence of the text of the statute says. But I want to be mindful of my time, so I'll end it there.
Okay, thank you. On behalf of the state.
Good afternoon.
Yes.
Again, may it please the court. My name is Andrew Coulomb. I'm here on behalf of the state of Tennessee.
Mr. Coulomb, can you answer me a procedural question right off the bat?
Mhm.
Is a post-conviction a hybrid? Is it a civil? Is it a criminal? What rules, how are we supposed to review, unpack the post-conviction statute?
Our Supreme Court has held that they are proceedings arising out of a criminal matter. And where the court has said it is sort of hybrid civil, they've talked about specifically tolling the statute. It's about tolling the statute of limitations. So that's where that appears to be limited, tolling the statute of limitations. Otherwise, the courts have uniformly said this is not treated like a civil action. In the Carter decision, the court said it's not a civil action for the purposes of the jurisdiction of the Court of Appeals. It's not a civil action for the purposes of waiving the timeliness of the notice of appeal. It's not a civil action for the civil action transfer statute. It's not a civil action. And then in Rule 28, Supreme Court Rule 28, the court says that rules of civil procedure do not apply unless specifically stated. And it certainly does not specifically state anywhere in the Post-Conviction DNA Analysis Act or the Act that civil procedural rules apply.
And so go ahead, I'm sorry.
No, please go ahead.
So the only place, this is my understanding, so the only place they've ever really couched it as civil and applied the civil rules is when they're dealing with the tolling of the statute of limitations. That's the only place our Supreme Court has ever said this is a civil issue.
Yes, the civil issue. They've taken inspiration for next friend action, things from civil area, but I'm not sure they couch it. This is a civil action when they did it. They just said we need some guidance on how to do this, and we can look there to do it. But this isn't a civil action. It's arising out of a criminal action. This is a collateral attack on a criminal judgment, on a sentence, and on a conviction. That's what the act is about. It's a manner of investigation, and then in furtherance of collateral relief. So it is not a civil action, and it's striking that in the estate's briefing they say, well, we're not collaterally attacking the judgment, we're not collaterally attacking the sentence, not collaterally attacking the conviction. This is not a collateral attack. But that's exactly what the Post-Conviction DNA Analysis Act is about. That is a manner of collaterally attacking one's conviction and sentence. And it's important, I think, that we begin with the language of the Act, because our Supreme Court has reaffirmed multiple times over the years, but certainly in the last 2 years, that we start with the language of the Act. In the Maxwell v. State order, the Supreme Court said that post-conviction review is afforded solely as a matter of legislative grace. It is entirely a creature of statute. In the Holland v. State decision from October of last year, the court said that the availability and scope of this lies within the direction or the discretion, excuse me, of the General Assembly. So we need to look first and foremost at the language of the statute. And in complete agreement, Judge Dyer, that the plain meaning of the act under the statute is that the probate estate does not have standing to bring a DNA claim. It is limited to that the people standing is limited to a person who has been convicted of and sentenced for certain crimes, including first-degree murder. As has been noted, a probate estate is not a person. It's not a live human being within the plain ordinary meaning of what person is understood. And certainly it's not a person who's been convicted of or sentenced for a crime. That's the Sedley Alley was, not the probate estate. So we begin with that clear principle there with the clear language of the statute, which is that probate estates are not contemplated as having standing, are not included as having standing. And even if you looked elsewhere, even if you looked outside of that, if you looked outside of the act and said, well, let's look elsewhere, see if we can find that. Like Tennessee Code Annotated 13105A19, which says a person includes a corporation, firm, company, or association, unless context dictates otherwise. An estate is not a corporation, it's not a firm, it's not a company, it's not an association, it's none of those things. And even if it were, context would dictate otherwise, again, because the estate was not convicted of or sentenced for a crime. So the plain language of the statute restricts standing to live human beings who've been convicted of and sentenced for certain crimes. And that's simply not the case here. So what the meat of the estate's argument then flows to, well, the estate just stands in the shoes of a person who's been convicted of and sentenced for certain crimes. So we'll just substitute them in. That's a survivability provision. And has been stated here, that simply does not exist in the act. It's not there. There is no survivability provision in the act. It does not exist. We know it could exist. We know the General Assembly could have enacted that, could have put that in there because it has done so elsewhere. For example, it did so in Title 20. We see in that section there about civil procedural rules that they did put survivability provisions. But we know they could. They didn't do that here. And Title 20 should not be imported into Title 40 here in the Post-Conviction DNA Analysis Act. Those are provisions that about actions that sound in tort or contract unless they deal with reputation or character. Most interestingly, if you look at the specific provision, it talks about instituting an action that where the person has already died. So the estate or representative starts the action. That's 25107. That is limited to wrongful death actions. This is not a wrongful death action. It's not a tort action. This is not damages being sought. This is a collateral attack on a criminal judgment. So survivability provisions is absent. It's not there, and it should not be read into it.
Because this is not a civil action.
Correct. Because it's not a civil. Absolutely, Judge Thomas. Because it's not a civil action, and because the General Assembly, in its wisdom, did not put that provision in the DNA Analysis Act. They didn't do it. It's not there. They could. That's what they certainly could if they felt that was a good thing to do, but they did not do it. And we shouldn't create that out of whole cloth. So the statute doesn't give the estate standing by its plain language. There is no survivability provision for it to stand in the place of Sedley Alley. And so then the estate sort of shifts gears and says, well, the court should create one. Due process demands it should create one. And it's clear, and even the state's conceded that the estate has conceded.
Before you get into creating it, I'll have one more question on whether it exists as it is. And it goes to the statement Mr. Clement made about if the state has to preserve all the evidence after Mr. Alley's execution, what's the purpose of preserving it if there's not some recourse, some cause of action that allows next of friend, the estate, however you want to look at it, to go in and challenge or examine that evidence?
I am not aware of how long the state must preserve evidence, especially if someone who's passed away and their judgment is now final. So I that was not in the briefing, so I have not researched that specifically. So I can't really say what whether it was the state was mandated to keep it at this point, whether they did so as a matter of law, and then why that may be. But what I can say is that the DNA Analysis Act is clear and it's plain, and it restricts the people who can do this. And under that plain language, it restricts it to live human beings who've been convicted of and sentenced for crimes. And that's where we begin our analysis, and the state submits we should end our analysis. That is where the standing emanates from. It emanates from the statute, which is a matter of legislative grace, and that is where everything should start and end.
Okay, thank you.
But the estate then says, well, the court should create one. Due process demands you to create one. Now, the estate does concede that there is no substantive due process right to DNA testing, which is true. We've had multiple decisions on that, especially the United States Supreme Court decided that in the Osborne decision in 2009. So we definitely know that. Mr. Alley actually, he litigated his 1983 action in federal court, saying he had a constitutional right to DNA testing, both substantive and due process. And the federal court said, no, you don't, not under these circumstances. So he'd already litigated that. But there shouldn't be, because our Supreme Court, when it talks about due process, when it used due process to, let's say, institute tolling, our Supreme Court was very clear, and it said due process allows a person with a present, statutory right to this to have an opportunity to bring the petition and bring the claims in a meaningful time and in a meaningful manner. And Sedley Alley had both. He had the opportunity. He had multiple opportunities. He had his opportunity in 2004. He had his opportunity in 2006. He also had his 1983 action. So you could say he had three opportunities in that regard. But he certainly did not lack for process on his DNA requests. He had his opportunity at a meaningful time and a meaningful manner. Twice, post-conviction courts took up his petitions, and they gave it a full analysis, and they said he did not meet the 4 statutory factors. Twice, this court looked at that, gave full decisions, full and thorough decisions about why those decisions should be affirmed. Twice, the Tennessee Supreme Court looked at that and declined review from a Rule 11 application. Twice, the U.S. Supreme Court reviewed the petitions for writ of cert that were filed about this, and twice declined to grant review. So there was a full opportunity, multiple full opportunities afforded to Sedley Alley regarding DNA testing. And due process does not compel this court to say, well, he should have yet another one. And though the estate makes much of the Powers decision, and the estate says, well, that's not fair, that some of the reasoning from the 2006 decision was later overruled in Powers. And it's true that some of the reasoning by this court was overruled by Powers a few years later. But there are 4 statutory factors had to be met. And and even if you ignored all of the wealth of evidence that went into whether there's a reasonable probability this may have changed the outcome of his case, whether you ignored his confession to police, his detailed confession to police, taken to the murder scene, whether you ignored his separate confession to his wife, you ignored the witnesses seeing his station wagon driving off from where the victim was thought to be abducted. Even if you ignored all of that, there were also concerns about contamination of the evidence. That's completely separate. And very importantly, the 2006 post-conviction court and this court found that the DNA petition was being advanced for the purpose of delaying the execution of judgment and the administration of justice. That is a separate and independent factor, and none of that has been touched by Powers. Powers did not affect that reasoning at all, and that is an independent statutory factor under the statute that the petitioner had to make, and the post-conviction court found he didn't make it, and this court affirmed, and that is an independent basis that Powers has no bearing on. So that wasn't unfair. There were multiple reasons why his DNA petitions were denied in 2004 and 2006, and several of them were completely unaffected by Powers. So it was not unfair that he had this. Due process was not offended, and due process does not compel this court to go beyond the language of the act, plain and ordinary language of the act, and say, we have to create a new process for this. Because he had a meaningful opportunity. He had the opportunity at a meaningful time and a meaningful place. So there is no procedural due process does not demand that we create this. And the state has, and there are very important reasons that the state has for this. I mean, beyond the state's, as the guardian, through the Attorney General's office, as guardian of the law, that we uphold the legal concepts that post-conviction should be construed by its language of the act, and that is a matter of legislative grace. Even if we get beyond that, as this court has acknowledged, the state has a very significant interest in finality of judgment. That's enshrined in state law, that is enshrined in federal law. The finality of judgment is a very important interest, that at some point, this must end. I know capital litigation in the thick of it seems endless, seems unending. I know that better than many. But eventually, when the capital defendant, prisoner, dies through natural means or otherwise, it ends. That there are no more collateral consequences to this, and that this must all end. And that is a very important right to the state, that judgment become final and be done. It is also an important right to victims. The Victims' Bill of Rights, Tennessee Constitution, Article 1, Section 35, number 6. The victims have the right, and victims' families have the right to a final conclusion of the case after the conviction or sentence. That at some point this must end. That they don't get a call 12 or 13 years after the death of the defendant and say, it started up all over again. That you thought this chapter of your lives are behind you, but it's not. This has started again. They're going to fight this even more, even though he's dead for more than a decade. This starts again. This is a very important right, constitutional right of the state and of the victims. And it's a reason why all over the country, the decisions in courts through decisions have said over and over again, when the defendant dies, this ends. The collateral attacks end, and this is a collateral attack. So for these reasons, there is no right under the statute, under the plain meaning of the statute, for an estate to bring the petition. There is no survivability provision, so the probate estate can step into the shoes of a defendant who no longer has an active statutory right to this anyway, since it has restricted to a person, which is a live human being. So it's not in the statute, and procedural due process does not demand that one be created, because Sedley Alley certainly had multiple opportunities at a meaningful time in a meaningful place, meaningful manner to seek DNA testing. For these reasons, the state of Tennessee respectfully requests that the judgment or the decision of the post-conviction court be affirmed.
Thank you very much. Rebuttal?
Thank you, Your Honor. I'd like to make a few points in rebuttal. First, just on the nature of the remedy here. My friend on the other side says, well, it's hybrid, but the courts really only recognize that in the statute of limitations context. And then he sort of concedes, well, in the next friend context, maybe as well. But two things I think are critical about this. First is all of that discussion about the post-conviction review being a hybrid are in the context of general post-conviction relief. And if anything, this separate DNA provision, I think, is even more obviously civil than your traditional post-conviction relief provision. But second, even if one were to accept my friend's argument that, this is primarily a concern in the statute of limitations context, well, the Sixth Circuit in the Krabs against Scott case, which we cite in our opening brief, specifically said that survivorship is a sibling or at least a cousin to statute of limitations. And I think they have the critical thing in common, which is they're not something that you would necessarily think that a special provision like this DNA post-conviction relief provision would address specifically. So they are the kind of things that where there's a well-developed body of law in the civil context, and it only makes sense to borrow that well-established body of law. The second point I'd like to make in rebuttal is just about whether Mr. Alley has really gotten due process here. And my friend wants to focus on the proceedings in Sedley 1 and Sedley 2. But with all due respect to the state, the idea that we got due process in a case where it is now admitted by both parties that the court applied the wrong legal standard is simply not a fair argument. There was no fair hearing in that case, given an admittedly wrong standard. And also, as I indicated earlier, that determination, even if it applied in the same standard, is not collateral estoppel or issue preclusion, which again is not the ground that the trial court ruled. And the perfect example is my friend's focus on the fourth factor. So in the context of an imminent scheduled execution, I suppose a court might say that this petition is being filed solely for purposes of delay and not to prove actual innocence. But if there's one factor that a posthumous petitioner ought to satisfy right off the bat, it's that they're not putting this in for purposes of delaying the sentence. The sentence already happened, regrettably. So we would satisfy that factor going away with the current petition, which is probably the best evidence that we're entitled to a fresh look at it, which we didn't get in this case because of the rule applied by the lower court. And that brings me to my third point, which is when my friend talks about due process and broader considerations, he's very much mixing apples and oranges with all due respect, because the argument that the state's making and the argument that succeeded would apply equally to an individual who passed away before they could ever file their first post-conviction DNA petition. As long as you're dead, you're out of luck. And I would imagine the logic of the government's argument would also extend to a person who's no longer in custody. And none of that is supported in the text of the statute. So let me finish just by emphasizing why I see the text, the purposes, and the constitutional principles all cutting in our favor. As to the text, it does not say a live person. If it did, I would be conceding we need to really look at the purposes and the constitutional principles, because the text is pretty bad for me. But it doesn't say a live person. It says a person convicted of a first-degree murder as relevant here. And with all due respect, that describes Sedley Alley to a T. Second, there's nothing in this statute, and I think this is consistent with Powers, that suggests that this provision ought to be given a miserly construction. To the contrary, there's a provision in this statute, 311, that specifically gives the courts broad discretion to make orders to effectuate the purposes of this act. And the one thing that the act makes clear is that the rules that might hamstring you in bringing a normal collateral attack pursuant to a typical Chapter 1 post-conviction provision challenge don't apply for purposes of the DNA provision. That's the very first line of the statute. And if I just finish on purposes, the purposes are exoneration and they are also finding the right person. And with all due respect, I mean, I have as much sympathy for the victims of a crime as imaginable, but their interests are not served if the wrong person has been executed for the crime and the actual perpetrator is at large. And that is exactly what the Supreme Court said in Powers. That interest extends. And then on the due process, just to point out, I do think there would be a fundamental unfairness here, given that the two things that seem to be used against Mr. Alley are the mistake in the prior proceeding and his execution. Neither of those seem like reasons that somebody should lose their right in court. And I just want to point out, this is an easier case than the Tennessee Supreme Court cases where they applied due process to find extensions or waiver principles or tolling principles under the statute of limitations. Because in all of those cases, and Seals is a perfect example, the statute is clear. The statute of limitations shouldn't be told. And nonetheless, the Tennessee Supreme Court tolls it anyways in order to avoid a due process problem. Here, all due process requires you to do is simply interpret a statute that is silent on whether it allows survivorship or a person who's passed away to pursue an action, and interpret that in a way that serves the remedial purposes of the statute. Thank you, Your Honors.
Thank you, gentlemen. Good arguments. And Mr. Clerk, if you will recess us.
This honorable court is now in recess until 2 p.m.